Hi everyone, welcome to today's webinar. We've got a massive number of people joining us today, so we'll be getting going in a couple of minutes. We're just going to let the Zoom room fill up because we don't want anyone to miss anything. Do please say hi in the chat while you're waiting for us to start. You're all really welcome. Hi, everyone who's just joined us. We'll be getting going in a couple of minutes. We just wanted to give everyone a lot of time to join us here in the Zoom room. We can see that already there is over 1,000 of you, which is really exciting. We're delighted to see so many people joining us for the first time and people who are returnees. Hi, everyone who's just joined us. We'll be getting going in about 60 seconds. We're just letting as many people as possible join us here in the Zoom room so that people don't miss anything. Okay, I am going to get going just with a little bit of webinar housekeeping. Big welcome to everyone today. We think this is going to be the most exciting and important webinar that the TUC does this year because it's all about the brand new Employment Rights Act. So we're joined today by Paul Nowak, TUC General Secretary, Jo Seery, Senior Employment Rights Solicitor at Thompson Solicitors, and hopefully very soon, Kate Dearden, the Minister for Employment Rights. But before we get going with the substantive part of the webinar, just to remind you all, we have live captions on the webinar. Click the button that's underneath the video that says show captions, and you'll be able to follow along with those. So many of you are already saying hello in the chat. This is fantastic. We want to see where you're from, what your union is, what experience you've got in the workplace. Please do share that. We've saved some time for questions with Jo after the main part of the presentation. So do please post any questions for her in the Q&A section, which again is below the screen, below the videos at the bottom of the screen. So, as I said, the webinar today is about the Employment Rights Act, which became law in December 2025. Now, this is really important for all workplace union reps, and this is the first in a series of training sessions that the TUC and TUC Education are going to bring you this year and next year. This webinar is kicking things off. We're going to have a series of regional events across the country throughout this year. There's going to be more webinars, online resources, training, and information. We're also going to send you regular newsletters. So by joining this session today, you're now looped in and you'll be getting all these updates as we produce them because the changes that this legislation brings in is so important for you all making a difference in the workplace. But first of all, I'm going to hand over to Paul, who's going to get us started on this subject and welcome you all today. So, Paul, over to you.
Well, thanks, Anna. And first of all, from me, welcome to everybody on the webinar. I think we had over 3,500 people registered for the call. We've got, I think, the thick end of 2,000 reps already online. So that's an absolutely fantastic turnout. And I want by starting by thanking everybody for joining us and to thank every rep that's on the call for what you do in workplaces. Thanks to Jo Seery from Thompson's, who's going to be talking to us later. And we're looking forward to introducing Kate Dearden, the Employment Rights Minister, in a few moments. I just want to kick off really by focusing, if you like, on the big national picture on the Employment Rights Act, about why the Employment Rights Act is so important and why it matters in particular to our workplace reps and workplace organisation. And I want to really just say three very quick things. The first one is, and this is a sort of people will know it, but the Employment Rights Act has the potential to make a huge difference to our members and to working people more generally. This is the biggest upgrade to our rights, including collective trade union rights, in a generation. And it's the culmination of years of hard work, of campaigning, of lobbying by trade unions. That doesn't mean the legislation is perfect. Nothing ever is. But it's a huge step forward, and we need to be ready to take full advantage of that legislation, because our job now is to make sure that our members and working people in general are able to make the most of those new rights. Now, I know Jo in particular will talk about some of the detail of the Employment Rights Act. I suspect Kate will as well. But this should be a transformative package of new rights in workplaces. And right now, our focus at the TUC is on making sure the legislation, the secondary legislation that flows on from that piece of primary legislation that was agreed in December, is implemented in full, on time, and in the right spirit, because we know that that's what will get more money into workers' pockets, and that's what will make sure that people feel the benefits of this legislation in their everyday lives. So we are currently responding to a whole range of different consultations about key reforms in the Employment Rights Act. I would just stress this is not about dry technical details. This is about making sure the legislation has real bite and that it does make a positive difference to millions of working people. And just to give a bit of a flavour, starting in April, millions of people will get sick pay from day one for the first time ever as a direct result of the Employment Rights Act. Millions more people will be able to thrive and not just survive, because they have the right to guaranteed hours. No more 0 hours contracts, meaning that you don't know from 1 week to the next how much you're going to earn. And there are going to be millions of people who benefit from things like a default right to flexible working, enhanced protections against sexual harassment in the workplace from customers, taking time off if you lose a loved one. All of this and more comes from the Employment Rights Act, as well as the collective rights. And I'll talk a little bit more about those in a moment. Takes me on to my second point, though. A huge raft of new rights. We have got a big job ahead of us, I think, to raise awareness of the Employment Rights Act and also to expose those politicians, including Reform and the Tories, who are opposed to it. Our polling shows very clearly, and it has consistently since the election in July 2024, that stronger rights at work are popular with voters right across the political spectrum. It's popular with Green voters, with Reform voters, with Labour voters, with Tory voters, and with Lib Dem voters, and for voters in Scotland and Wales for Plaid and the SNP as well. This is stuff that people like, and this is stuff that people support. So we've got to get a message across that this is a piece of legislation that is good for workers, it's good for good employers, and it's good for Britain. And I think that the reps on the call today have an absolutely crucial role to play to make sure that people know about new rights in your workplaces, that we're having conversations with colleagues about those new rights and what they mean, and we're showing what these new rights actually mean in practice. Now, that's important in and of itself, but it's also important politically. We know that some of our members are voting reform, some of our members are thinking about voting or leaning towards voting reform. And you can understand why people have got, sometimes feel disillusioned with mainstream politics. It can feel that change is a long time coming. People are fed up with stagnant wages, rising insecurity, and as I say, disillusioned. But I absolutely think we should use this legislation to show people that Reform are no friend of working people. Reform MPs voted at every single stage against this piece of legislation in the House of Commons, and they and the Tories opposed it. The Tories, I should say, and other opposition parties opposed it in the House of Lords as well. Reform are threatening, as part of their Great Repeal Act, to scrap the Employment Rights Act if they ever formed a government alongside the Equality Act and other key pieces of legislation. I think we've got a real job on our hands to get across the message that the Employment Rights Act is good for working people, it's good for this country, and we need to expose those politicians who are opposed to people having decent rights at work. Third and final point from me, I think this is a set of new laws that are really important for individual workers. They're really important for our movement as well, because I think we need to use these new rights to get into new workplaces, to talk to more potential members, and to grow our movement. And I think we've got a historic opportunity to turn around. I mean, if you look at the last few years, our membership has basically been flat. And this is an opportunity to go from a trade union movement that is pretty much stagnant membership wise to a trade union movement that's getting into workplaces up and down the country. Those new rights in the Employment Rights Act will make it easier for us to access the workplace. They'll make it easier for us to access workers digitally. They'll make it easier for us to organise workers. They'll introduce things like electronic balloting so that we can ballot members more easily. It is just vital that we take advantage of all of those new rights. Now, in Australia, where the Labour government in Australia introduced a similar pack of legislation, Australian unions have taken that legislation and have turned it into membership growth of some 12% since that legislation was introduced. And I think we've got the real potential to do the same thing here. And it is worthwhile reflecting, as I say, that, for the first time, certainly, that I've been a trade union rep, an activist, and officer, something like, no, I don't want to give my age away, but maybe about 37 years. This is the first time that a government has positively repealed anti-union legislation, has got rid of the 2016 Trade Union Act, removed restrictions on check-off, protection from unfair dismissal for workers taking industrial action, a whole range of other things, as well as the minimum services level legislation that we fought so hard to stop the Tories introducing towards the tail end of their time in office. But these are really important new rights that level the playing field for unions, allow us to get out into new workplaces and organise workers. So we really do need to seize the moment, use these new collective rights to rebuild, to refresh and renew our membership and to get more people into trade union activity. So I'm going to finish on this point. The Employment Rights Act is a really important opportunity for us to win fairness and equality at work. It's a real important opportunity for us to rebuild our movement. That will only happen if the reps on this call and reps in workplaces up and down the country really seize the mettle and make sure that we're making these new rights live and breathe in workplaces. There's a world of difference between having a new right and enforcing a new right, and I know that that's what our reps will be making sure happens in workplaces up and down the country. That's all I wanted to say by way of introduction. I think I'm now in a position to say that I'm able to introduce Kate Dearden, who's going to be our next speaker. Kate, I think a few people on the call will know, but she is the Minister for Employment Relations. She's the minister who got the legislation over the line towards the end of December last year, and she is the person who is driving that process of making sure the secondary legislation is absolutely watertight as we go forward, but also the person who's driving forward the rest of the government to make work pay agenda as well. And that's a really important set of reforms that I know Kate is passionate about and is leading. I won't say much else by way of introduction other than to say that as well as being a minister and a parliamentarian, Kate is one of us. She worked for a number of years for Community Union. She's a trade unionist through and through, and I'm absolutely delighted that she can join us on the call as Minister for Employment Relations, Minister for the Employment Rights Act. Over to you, Kate.
Thanks so much, Paul. It's really, really lovely to join you, and thank you so much for inviting me to today's webinar. And wow, what a turnout by the looks of things. It's really, really brilliant to see so many people join us on this call, and I'm really pleased to have the opportunity to talk to you about all our work in government to strengthen employment rights, strengthen workers' rights, and this landmark piece of legislation, the Employment Rights Act, that I was really, really proud to steer through Parliament towards the end of last year. And it marks such a major milestone for us as a government and for our ambition to bring employment rights legislation into the 21st century. As Paul touched on, I am from the trade union movement. It shaped my values, it shaped my politics. It was absolutely why I wanted to stand to be a member of Parliament, and for us as a government to have this opportunity to update and upgrade employment rights legislation is such a significant one. And I know the importance of this legislation to the movement, to all of you as trade union representatives who deliver on this agenda day in, day out. And I remember fondly a few years ago when a number of us across the union movement came together to discuss the changes that we wanted to see from the next government, from the next Labour government. And to now be that minister steering through the legislation is an honour and a privilege every single day. I thought I'd touch on a couple of things. Starting off with the case for change, because I think it's important for us to reflect, and you all know this every single day, the conditions that we know working people across the country are working and facing in their workplaces and across our economy. As you all know, those millions of workers that are still in low-paid, insecure, or poor quality work, affecting their finances, their financial stability, and of course their health. Too many people are unable to work due to long-term health, and despite those high employment levels, the productivity of our economy has lagged behind other major economies. And at the same time, more than 1 million people are on a 0 hours contracts, and only 1 in 6 low-paid workers ever moves into better paid work and stays there. That's why we set the country on a path of national renewal, all about building a country in Britain for all, founded on security, on respect, and on opportunity. And delivering that future, for me, for the government, and for this department, means creating an economy that works for working people, that is productive, profitable, and growing. And we know that we can't build that robust and growing economy on a foundation of employment insecurity. So that's why instead we're building on an economy based on job security and on fair reward for hard work. As Paul touched on, the world of work has changed dramatically in recent years. And you all know this and will have seen this, whether it's through technological change, through new working patterns and the rise of the gig economy. Yet we know that UK employment law has simply not kept pace. And that has allowed lots of loopholes that let some employers undercut responsible businesses. And this race to the bottom has eroded living standards and created that uneven playing field, harming both workers and businesses, those good businesses who are trying to do the right thing. So what's our response? And our response is our plan to make work pay, which hopefully you all know lots about. And that plan will bring our employment rights framework into the 21st century, extending those protections that are already offered by the best British companies to millions more people and workers across the country. Strengthening this underlying framework will make more secure and predictable work for people, put more money into people's pockets, and really strengthen those foundations that I touched on before that underpin a modern economy in the 21st century. And our reforms show that fairness and economic growth absolutely go hand in hand. So when we look at the Employment Rights Act, as I've touched on, it's the major first phase of delivering our plan to make work pay, modernising those employment rights for the first time in decades. The Act has now passed towards the end of last year, and we're now in those detailed bits of work to make the reforms go live. For instance, we'll shortly consult on how to roll out the new right to guaranteed hours, and are consulting right now on how to roll out the new protections from fire and rehire. But these reforms are no longer a distant dream. We're bringing them in as fast as we can, and many are happening right now. We've already repealed restrictions on trade unions, such as the Minimum Service Levels Act, and that was quite a moment for me in signing that piece of legislation away. And in just a few weeks, workers will receive statutory sick pay from the first day of illness. And for the first time, low earners will be eligible to receive it, and that's a significant moment for us in a few weeks. At the same time, we will strengthen protections for workers who blow the whistle on sexual harassment and enable working people to have a meaningful right to organise by simplifying trade union recognition processes. And later this year, we'll be giving trade unions a clear statutory right of access to workplaces and introduce an obligation on employers not to permit the harassment of their employees by third parties. So this act is really transformational. It'll help working parents, carers, and people facing personal challenges stay in work and stay productive, extending new rights from day one of employment, including paternity leave and unpaid parental leave and improved access to flexible working, as well as all those rights that I've mentioned for you as organisers and for the trade union movement to represent and access workers all across the country in different workplaces. Looking to next year, from January, we'll reduce the unfair dismissal qualifying period to 6 months, meaning an additional 6.3 million employees will be protected. So altogether, and I've raced through lots of bits of this legislation, but it is so significant, and I wanted to just touch on a few really impactful things that happen in the near future, and obviously picked a few things to highlight. But I could be here for the next few hours talking about how significant this bill is and just the difference it will make to people. Because altogether, over 18 million people, nearly half the workforce, will gain stronger rights, greater fairness, and more security at work because of the work that this movement has done in shaping and building and creating this legislation, and because of us as a UK Labour government in delivering it and we delivered it in the first 100 days of our government. That's our commitment to this agenda and to this work. And now we are in the implementation stage and the part where people really start to see and feel that difference. Strengthening employment rights for me is not an add-on to our economic strategy. It's absolutely at the heart of it. By improving job security, ensuring that fairness and levelling the playing field between good employers and bad, we are building a labour market that supports workers and their families and supports that long-term economic growth. And that's how we make work pay for businesses, for workers and for the economy as a whole. And I'm so proud to be a minister in this government and to be part of a party that delivers for working people every single time we're in office. A party that delivered essential maternity rights some 50 years ago, a party that introduced the minimum wage back in 1999, and a party that's now bringing in the Employment Rights Act and guaranteed hours, better protections against unfair dismissal, and increased trade union powers today. And we're so looking forward to working with all of you in the next steps and implementation of this and to hearing about the real difference it's making on the ground in your workplaces and to your lives. So thank you so much for all your work and for everything this movement does. And I'm so looking forward to continuing working with you as we build our protections and transform our economy and workplaces across the country. Thank you, Paul.
Thank you so much, Kate, for getting us really excited to hear more about what is coming this year. And we're going to be diving into the detail a little bit more with Jo in a second. But yeah, thank you. It's great that you were able to join us. And thank you, Paul, as well, for your introduction to the Act. So both Kate and Paul have mentioned some of the changes that are coming in the Act, but what we're going to be focusing on today with Jo are the changes that are coming into law in April, because as I said, there's a lot coming. We're going to be doing training events all year for you with various changes and the details that you need in order to represent your members and make a difference in the workplace. But this is just the first one. So Jo Seery is someone who needs no introduction. She's done many events with us before. She's a senior employment lawyer at Thompson Solicitors, a legal expert, and is deeply involved with the detail of the Employment Rights Act. She's going to be taking you through the changes that are coming, but we want to emphasise that this is a training event today. Please don't act on this as legal advice. That is something that you would need to consult your union and their legal teams about. But this is a training event to bring you up to speed with what is coming. So, Jo, over to you. We'll get the PowerPoint loaded up, and then we're really excited to hear more about what the details are.
Right, thank you very much. Thanks for that introduction, and thanks for covering my back with that introduction as well about not taking it as legal advice. That's great. And I'm really pleased to be on this call, and thank you so much for inviting me to speak. I mean, as we've heard from Paul and Kate, really the Employment Rights Act puts front and centre the importance of having individual employment rights, and also more importantly, something that we haven't seen for years and years is putting trade union rights also front and centre. So we are, as Kate said, in the first phase, and we are now well and truly on the road to implementation. We had the repeal of the Minimum Service Levels Act when the Act came into force on the 18th of December 2025, which was a really pernicious piece of legislation which struck at the very heart of the union's right to strike. And we've had the repeal of the restrictions under the Trade Union Act in relation to industrial action, which came into force on the 18th of February. So what I will do is I will focus on, as Anna said, what's coming into force in April. So if you could have the next slide, please. Great, thank you. So this is my roadmap. We are well and truly on the roadmap to implementation, as I've already said. So this is what I'm going to focus on in this session and go into some of the detail. I'm going to look at what's changing and what you need to know. Forewarned is forearmed, as they say. And so without further ado, I'll turn to the next important first right. So looking first then at trade union recognition, and Paul talked about getting more unions into the workplace. So this is another really positive reform that's taking place. Currently, if an employer refuses to recognise a trade union voluntarily, the union can apply to the Central Arbitration Committee, the CAC, to obtain statutory recognition. But statutory recognition is hugely complex. I've set out in the slide a summary. I don't have managed to do this, but a summary in the table there, which shows that the union has to satisfy admissibility tests before the CAC will even consider a union's application. So currently, a trade union's application will only be accepted by the CAC if it can show that 10% of the membership of workers, in the bargaining unit are members of the union, and that a majority of the workers in the bargaining unit would be likely to obtain a majority in a recognition ballot. So it's quite onerous, and provided those two admissibility tests are met, the union can then only at that point make an application for statutory recognition. Then, where a union has a majority in the bargaining unit on application, the CAC can decide to automatically recognise the union without holding a ballot. But more commonly, the CAC will still require a ballot of the workers if the workers want one, or where there are doubts about the union, whether it has the majority of the CAC, or even if the CAC thinks that a ballot will further good industrial relations. So the union must obtain a majority in a recognition ballot, and at least 40% of the workforce in the proposed bargaining unit must support recognition. So these are massive hurdles for the union to overcome. In the second column, I have set out the changes in the recognition process. So first of all, the Employment Rights Act introduces a power on the Secretary of State to introduce regulations which will reduce the admissibility test with a required percentage test of between 2% and 10%. Secondly, it will remove the requirement to show that the union is likely to obtain a majority in a recognition ballot in the admissibility test. So that element of it goes, and many of you will have had to get evidence by way of petitions in order to support that aspect of the admissibility test. Also, the third thing that goes, as you can see from the second column there, is the requirement that the union must show it's likely to obtain a majority in a recognition ballot. And instead of the 40%, it will simply be replaced by a simple majority. So if a simple majority vote in favour, then the union can apply for recognition. There are also some additional changes that weren't in before, and that includes that the CAC will provide employers 5 working days' notice to provide certain information about workers and the bargaining unit. Importantly, any worker who joins the bargaining unit after the application day, so after the application has been made to the CAC, then they are not to be they're not eligible to vote in the ballot, and they cannot be counted towards the number of workers in the bargaining unit. So the idea of watering down the bargaining unit is protected. And the fact that the employer voluntarily recognised a non-independent union will no longer prevent an independent union from applying for recognition. So these are really significant changes. So if we look at the impacts of those, you can see that the removal of the requirement for the union to show at the admissibility stage that it's likely there will be a majority in favour of union recognition will remove a significant hurdle for unions where the margins are really close. Employers will also be prevented from flooding the bargaining unit, as they will be unable to include new recruits into the bargaining unit once the union has submitted its application. So it doesn't undermine union density, and it will prevent sweetheart deals from undermining a union's application for recognition. But I think for me, the key point is a more simplified recognition process will mean that if 10% of the workers in the bargaining unit are members of the trade union, then they can apply for recognition and benefit from collective bargaining. And so these are good recruitment points to make for workers to know at a time when it's really hard going for individuals and not getting the pay rises that they expected. Good collective bargaining arrangements in place will protect those workers. Turning now to collective rights. So I want to look at collective redundancy. These again are coming in April. So currently the position is that an employer who is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less must collectively consult the appropriate representatives before the redundancies can go ahead. So where the union's recognised, they will be the appropriate representatives. The definition of redundancy is also very wide, and this means that the obligation to collectively consult with the appropriate representatives applies in a fire and rehire situation as well, because the definition of redundancy is different to the individual rights. Redundancy is defined as a dismissal for a reason not related to the individual. So again, an important right. In April, what happens is, this is the first stage. Sorry, if you can just stick back with so currently the maximum protective award. So if a claim succeeds at an employment tribunal and there has been no collective consultation, an employment tribunal can award a maximum protective award. So the protective award is the compensation of 90 days pay per affected employee. What will change in April will be the maximum protective award will increase. So it doubles from 90 days to 180 days for those dismissed on or after the 6th of April 2026. So this is hopefully going to be significant, because what I've got on the second point of the slide is the 25% uplift. Now, that's not new legislation under the Employment Rights Act. That currently exists, but that 25% uplift will apply to the 180 days. So that will mean that where the employer fails to collectively consult, an employment tribunal will consider whether or not the employer has complied with their code of practice on dismissal and re-engagement. And if they haven't consulted, they won't have done. So a tribunal is likely to apply a 25% increase to the protective award, which effectively gives another 45 days on top, giving a total of 225 days. Stick with me on the maths. And then that will amount to equivalent to about 32 weeks' pay. So there are significant costs for an employer if they fail to consult, both in a redundancy situation, so where there are 20 or more employees to be made redundant within a period of 90 days, and in a fire and rehire situation. One of the things that we did argue is that it might have been a more effective deterrent, particularly for the likes of P&O, had the government introduced interim relief. But this was rejected, and instead there is now currently a consultation about looking at another trigger for the obligation to collectively consult, which will apply across the organisation. So moving from the collective rights to the individual rights. Currently, employees are entitled to unpaid parental leave if they have got 1 year's continuous service by the date the leave starts. Now, the Employment Rights Act gives the power for regulations to remove that 1 year's service, and that's set out in the Employment Rights Act parental and paternity leave, removal of qualifying periods, consequential amendments regulations, so quite a mouthful. But the important thing is the removal of qualifying periods goes, meaning that the right to take unpaid parental leave will apply from day one. And parents have already got the right to give notice to their employers that they want to take unpaid parental leave, and that's been applied since the 18th of February. In terms of paternity leave, then currently employees have got to have 26 weeks service ending with the 15th week before the expected week of birth. So that takes a bit of time to work out. Thankfully, that goes as well under those regulations that I've mentioned, so that employees will qualify for the right to take paternity leave from day one. So that will apply to the birth of a child and to adoption as well. And the employment rights also removes a restriction preventing paternity leave from being taken after shared parental leave. So currently, all paternity leave has to be taken before shared parental leave. And shared parental leave is not the unpaid parental leave that I've just talked about. That's another separate right. So removing that strict restriction means that employees get to take both the paternity leave and the shared parental leave. And just to confirm, in terms of the paternity leave right, the day one right will apply where a child is born or is expected to be born on or after the 6th of April 2026, or a child is placed for adoption on or after the 6th of April 2026. And it's just important to emphasise that we're talking about leave. There are no changes to statutory paternity pay, which is currently £187.18 per week, and which will increase to £194.32 on the 6th of April, which is when these rights come into force. So in terms of what the action points there are for unions, well, the first thing is to ensure employers' policies match the statutory minimum. So you'll need to check if there are qualifying periods within your own policies, and that the individuals will have a day one right. We also have to ensure that employers notify staff of their enhanced rights and consult on the changes to their policies and procedures, and that'll be particularly important if the policy and procedure is part of the contract of employment. That's usually rare, but in case somebody does have a contractual right, then they should be consulted about it. And if they're not, employers don't inform their staff, then they're going to be faced with grievances. So, it's a no-brainer really for employers to inform staff. And one other point that I think is quite interesting to know is that research that was carried out by Pregnant Then Screwed revealed that countries that have got 6 or more weeks paternity leave have a smaller gender wage gap. And I want you to hold that thought, because I'll be coming on to look at equality action plans and what might be one action plan for an employer to try and reduce the gender pay gap. So turning next to statutory sick pay, both Kate and Paul have already mentioned this. And it's again, sickness absences once again in the news I hear today. So currently, entitlement to statutory sick pay, or SSP, is limited to employed earners who meet specific eligibility conditions. So to qualify, an individual has to be classed as an employed earner. They have to have undertaken some work for the employer. They have to have been ill for 4 consecutive working days, and they have to have average weekly earnings at or above the lower earnings limit, which is currently £125 a week. So that means that currently statutory sick pay is only payable from day 4 of the first day of sickness absence. So the first 3 days are known as waiting days, because those are when you're waiting for SSP, and then on the 4th day, SSP becomes payable. So what will change? From the 6th of April, statutory sick pay will be payable from the first full day of sickness absence. And the 3 waiting days are abolished, and the lower earnings limit is removed. And they're removed by the Employment Rights Act Statutory Sick Pay Consequential Amendments Regulations, which were laid before Parliament just last week on the 5th of March. They're the regulations that remove the requirement to satisfy the LEL and the requirement to have 3 waiting days. So removal of the waiting period might enable those who are signed fit for work on a phased return to work basis. So somebody who works 5 days a week, but they're signed fit to return to work 3 days a week, may be able to qualify for SSP for the other 2 days. It will depend on whether or not the employee is actually incapable of work, etc. But a fit note from a doctor recommending a phased return to work as a precautionary or for convalescent reasons might be sufficient to deem the non-working days as days of incapacity. So that's something that's not been able to happen before. In terms of removal of the LEL, that's obviously good news, because that means low earners will now qualify for SSP. The key thing is what will that rate of SSP be? So the government consulted on this, and SSP is to be calculated at the standard rate, which is currently £118.75, or 80% of average weekly earnings, whichever is the lower. So whichever is the lower of that. So while all low earners will receive some sick pay, one of the consequences of this is that a worker with average weekly earnings of £125 would now receive £100, which is less than they would receive currently. But in the explanatory memorandum to the regulations, the consequential amendment regulations, it states that there will be transitional provisions which will protect those who are off sick at the time the regulations come into force. And what the explanatory note says is that it will protect those who are already receiving SSP, who would otherwise see a reduction in their weekly rates because of moving from either the lowest of the statutory rate or the 80% rate of pay. So it looks like that somebody who's off sick already at the time the regulations come into force, that their position will be protected. But I don't know the details of that because I don't have the regulations currently. So I'm not able to give you more details about that. So looking then at what points to consider as a result of these changes, how's it going to impact you as reps? Well, we've heard that employers are anticipating an increase in sickness absence, and then you will have heard on the news, as I did today, that it's been reported that there's been an increase in the number of fit notes that doctors have been issuing, although it made it sound as though it was a massive increase, but I didn't think it was that massive an increase. But employers will be hot on this, and they'll be expecting people to take more sickness absence, fueled by reports in the press, and also reviewing their sickness absence and their attendance management policies. And it's likely that they're going to become more rigorous, that managers are going to be more proactive in monitoring sickness absence. That's going to be by line managers, as I say, and they're going to be looking for patterns of behaviour. So one of the things we need to be on the lookout for is whether or not that's going to have a discriminatory impact on those who've got caring responsibilities, or those who disabled workers, for example. So it could again lead to increases in grievance and disciplinary proceedings on the basis of sickness and attendance policies. The other thing is that small employers may fail to pay SSP from day one because they're just not informed, or they're just ignoring the legislation. Not that I can really say that, but you'll have more experience of that than me. But the other thing, from previous research, there was some evidence that employers may reorganise shift work so that they don't roster workers who are off sick on a particular day. So again, these are the things that, you know, as reps, you're going to need to watch out for in terms of some tactics by employers that may be adopted when the statutory sick pay provisions come into effect from the 6th of April. So turning now to the next provision. So this is a real whistle-stop tour, isn't it?
Jo, just while you catch your breath there, I just want to let you have a second. Everyone who's watching, we will absolutely share the recording with you. I forgot to mention that earlier. I'm sorry. And we will share any resources that we think will be helpful to you, including Jo's presentation. So please don't worry. You won't miss out on if you're not making notes. Sorry, Jo. Please continue.
Oh, no, it's all right. Thank you. The other thing is in terms of enforcement of sick pay, well, that will fall within the remit of the Fair Work Agency, and that's expected to be established on the 7th of April 2026, so the day after the amendments to the sick pay provisions. And this will bring together a number of existing agencies, so the Employment Agency Standards Inspectorate, the Gangmasters and Labour Abuse Authority, and HMRC's National Minimum Wage Enforcement Team. They'll all be brought together under one roof, which is the Fair Work Agency. And the Fair Work Agency is then essentially going to be responsible for enforcing relevant labour market legislation. And I've set that out on the right-hand side of the slide, but just to focus on a couple of those. So it'll be responsible for enforcing SSP, which I've already mentioned, payments of the national minimum wage, payment of holiday pay and record keeping of holiday pay, provisions under the Modern Slavery Act, payment for social care workers that are going to be paid in accordance with ratified agreements under other provisions in the Employment Rights Act on social care negotiating bodies. So it's going to cover a huge area, and it's going to take some time, I think, really, to take over all of that responsibility. So I don't think, you know, on the 7th of April, everything's not going to all come together on one day. And that's the thing that we're going to have to keep an eye on in terms of how SSP is going to be enforced, for example. So the Fair Work Agency will also be able to issue a notice of underpayment to employers, which specifies that the amount payable must be within 28 days, otherwise there'll be a penalty, which will be payable to the Secretary of State. So it does mean that there will be major consequences for employers who fail to pay SSP and holiday pay and keep records of holiday pay. The other thing that's very, very new, and some of you might be surprised to see this, is what I've put on the slide, is that the Fair Work Agency will also be able to provide legal assistance on behalf of a worker if the worker has a right to bring a tribunal claim but doesn't bring one. So this is a significant change, but it's not really clear how that's going to work in practice. Neither is its remit to provide legal assistance for employment-related proceedings. Now, that might be something as much as helping claimants with holiday pay claims, how to ask their employers for it, etc., how to follow up on that, how they will support them. And it might also include helping employers to understand the procedural requirements and what documents and records they are required to keep. The Fair Work Agency will also recover its enforcement costs. But, you know, as many others have said, how effective the Fair Work Agency is going to be will ultimately depend on the resources that are given to it. So again, we need to keep an eye on that. Turning now to provisions on whistleblowing. Again, both Paul and Kate mentioned this. So the provisions on whistleblowing are set out in the Employment Rights Act 1996, and they are amended so that they expressly provide that a qualifying disclosure includes a disclosure that sexual harassment has happened, is happening, or is likely to occur. And sexual harassment, when it refers to that, is the definition that is set out in the Equality Act, which is on the slide there. So it's unwanted conduct of a sexual nature which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for them. So what is the impact of this change? Turning, next slide. So the current position, some of you might be thinking, well, how is it going to make a difference? The current position is that workers do have the right not to be subject to a detriment if they blow the whistle about sexual harassment, or dismissed if they blow the whistle about sexual harassment. And the disclosure must be in the reasonable belief of the worker, amount to a breach of a legal obligation. So arguably, sexual harassment amounts to a breach of a legal obligation because it's a breach of the Equality Act. It's likely to be in the public interest because blowing the whistle on sexual harassment will lead to the protection of women at large, be that colleagues or clients, customers or service users. It might be in breach of health and safety because it creates an unsafe working environment, or it might be in breach of, it might amount to a criminal offence because it amounts to an assault, for example. But the change is still significant because it does mean that individuals will be able to pursue a claim for interim relief if they are dismissed for blowing the whistle on sexual harassment. Yes, you still have to show that that is the reason for dismissal, but it does mean that there is an option to claim interim relief. And so a tribunal may order that if an individual's got a pretty good chance of winning their case at a final hearing, then they can order that the employer either reinstate the employee or continue to pay their full salary until a full hearing. And we all know how long it takes to get to a full employment tribunal hearing. Another significance of this measure is that it means confidentiality clauses will be void, so they're not valid, if it attempts to prevent a worker from blowing the whistle on sexual harassment. And it's hoped that these measures, together with the preventative duty on employers, which is already in force and has been since the 26th of October 2024, will encourage others to come forward, or either reporting it to their employer or to the regulator like the EHRC. So what can we do? So we can review existing policies, making sure that sexual harassment is not tolerated, and setting out clear reporting lines so that people who do want to blow the whistle know where they can go, and people who want to report sexual harassment know are clear about who they can report that to and what the procedures are for resolving it. We can also review contracts for confidentiality clauses and get them removed because they are void. If the employer seeks to insist on a confidentiality clause, we can ask them why, and we can ask them, because it's not going to protect them if it's void, and seek to remove confidentiality clauses in settlement agreements on the basis that they're void under section 43G 43J, sorry, of the Employment Rights Act, which I've set out there, and you can see any provision and agreement to which this section applies is void insofar as it purports to preclude the worker from making a protected disclosure. Sexual harassment is a defined and expressed protected disclosure. So a confidentiality clause which would prevent somebody from disclosing the sexual harassment will be void. I mean, there are exceptions if an individual wants to have a confidentiality clause, but that's a separate matter. So looking now to equality action plans. So the Employment Rights Act provides for equality action plans, and it provides for regulations which will require employers to develop and publish a plan which shows the steps that they are taking with regard to prescribed matters relating to gender equality. So the two prescribed matters relating to gender equality are addressing the gender pay gap, so opposed to just the current provision is that employers must report on the gender pay gap. This takes the next step, requiring employers to address the gender pay gap, although I suppose really, given the government's fact sheet, which shows that the average gender pay gap is 12.8%, it really should be about reducing the gender pay gap. And also what measures the employer is going to introduce to support employees going through the menopause. The key thing is that this only applies to employers with 250 employees or more. And as I say, it will only be introduced on a voluntary basis in April 2026, but it will be mandatory from 2027. So next slide. Just last week, or I think this week, weeks emerging, to encourage employers to comply with their voluntary duty, it has produced guidance to try and encourage employers. And that guidance states to employers, you might want to use this voluntary year to practice before it becomes statutory. So before it becomes a mandatory right. So there's a year's lead-in effectively for employers to get it right. So good employers will be voluntarily trying to comply with the duty to set up equality action plans. And what the guidance says is that employers must choose at least one action to address the gender pay gap. So it gives some further links and guidance on what things might influence the gender pay gap. So these are wider things, not just, looking at how work is conducted, the abilities of individuals, where they've got caring responsibilities, the kind of sectors that they're employed in. Employers must also choose at least one action to address the menopause. So this gives you a flavour of what the mandatory regulations might look like, because the wording, as you can see in the guidance, is must choose at least one. So one of those might be one of those that I identified earlier on, which would be increasing the paternity leave provisions, because that has an effect of reducing the gender pay gap. So that's why I said hold that thought when I was talking about the day one right to paternity leave earlier. It also suggests that employers should consider and take into account individuals' characteristics. So if they're disabled or they've got caring responsibilities, and they must create meaningful change. So by tracking progress against those action plans. So it really is intended to, become more of a tick box and become more of an action plan. Employers who are willing to engage on a voluntary basis can publish their equality action plans on the current gender pay gap service, and there's no time limit for doing that for this year on a voluntary basis. And as I say, there is further guidance. There are 18 recommended actions which cover steps employers can be taking in respect of recruitment, in terms of promotion and development, in terms of building diversity and increasing transparency and supporting employees. So there's an awful lot of information which the government has published in a real attempt to encourage employers to take action rather than just do nothing and sit back and wait until the provisions come into force. When the provisions do come into force, and they are mandatory, the deadlines will be the 30th of March, by which employers will have to submit their equality action plans for public authority employers, and the private sector employers and voluntary organisations will have to publish their equality action plans by the 4th of April 2027. So early on in 2027. So it's sensible for good employers to look at introducing and complying with the voluntary action plans. So those are all the provisions that are coming into force in April, and that will soon be upon us. But what I also wanted to do was, I know I said I would just look at April, but I thought it would be important to flag two of the big issues that are coming up in 2027. And the reason for me picking up on these two is because I know that employers are already taking steps to prepare for these when these come into force in January 2027 or later on in 2027. So I thought it useful to look at two of those areas, as I've said, and I want to look first at fire and rehire. So to recap, the current position on fire and rehire occurs when the employer proposes to change terms of the contract, which the employees don't want to accept. The employer then threatens dismissal in order to implement those changes, and then those changes, the individuals are then subsequently dismissed. So if employees continue to object to those changes, the employer will usually issue notice of dismissal and then seek to re-engage employees, usually on inferior terms and conditions. And where the contract is terminated in those circumstances, that amounts to a dismissal in law. And as you all probably know, the employer's got to identify a reason for that dismissal. The reason that they will rely on will be some other substantial reason, and case law has established that some other substantial reason is a sound, good business reason for maybe a reorganisation, and that will be sufficient to establish some other substantial reason. So it's not something that an employment tribunal will investigate, because it considers that an employer has a right to manage its business in a way which it thinks is sound. So they won't make an assessment of the advantages to the employer's business. They will just consider whether or not the employer has made a sound, good business reason. And so we will all know about the P&O debacle, where the employer decided that it would just dismiss almost 800 employees and re-engage them through an agency on lower terms and conditions. There is a code of practice on dismissal and re-engagement, and that came into force on the 18th of July 2024. But it doesn't have statutory, it's not legally binding. It can be taken into account by tribunals, but breach of it itself doesn't automatically give rise to a legal claim. So what will change? Well, fire and rehire is not going to be outlawed altogether. Instead, what will happen, it will become automatically unfair for employers to use fire and rehire if the reason for the dismissal is a restricted variation, or the employer imposes the restricted variation such that the contract is treated as a dismissal, or because the employee refused to accept a restricted variation. So restricted variations are prescribed. So these include a reduction in pay, And that also includes changes to targets where the pay is related to achieving those targets. So typically, you know, a commission or a bonus type payment or an enhancement. Any variation to pensions, that's a restricted variation. A variation in the number of hours an employee is required to work. A variation in the timing or duration of a shift, although that's subject to another consultation which is ongoing at the moment, and a reduction in the amount of time off which the employee is entitled to. So all those variations there are restricted variations, and if an employee is dismissed because of those restricted variations, then they will be treated as automatically unfairly dismissed. The other important thing here is that adding a variation clause which applies to any of the above. So, for example, if you could say a variation clause might include something like to work such shifts in accordance with the needs of the business, that would be a variation clause. Now, that too will be a restricted variation, but that won't be the case until the legislation comes into force. And that has been changed. Originally, the fire and hire provisions were going to come into force in October 2026. They've now been pushed back to January 2027. And so what that means is it leaves workers vulnerable to employers taking steps to impose variation clauses before it becomes unlawful to do so in January 2027. So this is the thing that, you know, reps need to watch out for in any negotiations if employers are trying to introduce variation clauses. The other thing to watch out for as well is that employers might seek to redefine what amounts to pay and redefining them as benefits in kind, elements of pay, and not basic pay, but elements of pay. Which are important to workers, and try and recategorise those as either an expense or a benefit in kind. And I'll come on to that in a minute. However, there is always a but. Dismissal for a restricted variation won't be automatically unfair. Next slide, please. If the reason for the restricted variation was because the company was in dire financial straits. So how the legislation describes this is that it won't be automatically unfair to dismiss somebody for a restricted variation if the reason for the restricted variation was to eliminate, prevent, or significantly reduce or significantly mitigate the effect of any financial difficulties which at the time of the dismissal were likely in the immediate future to affect the employer's ability to carry on the business as a going concern in the case of private employers, and in the case of a public sector employer, the financial sustainability of carrying out the employer's functions are going to be affected. So in all the circumstances, the employer couldn't reasonably have avoided the need to make those variations. So the importance about this is that it's got to be real financial difficulties. So a local authority who says, look, you know, think we might be in some financial difficulties in the future, they're not going to be able to rely on it because it's a fairly stringent test on employers. They've got to be sort of like real financial difficulties. And as I say, they've got to be applying at the time of the dismissal. So something that they think they anticipate in the future, and it's going to be quite difficult for the employers to rely on that. So what happens if the change isn't a restricted variation or financial difficulties exception applies? Well, where the change is not a restricted variation or the financial difficulties exception applies, the dismissal won't be automatically unfair, and ordinary unfair dismissal principles will apply. And what the Act does here is it codifies the current case law, so it puts it onto a statutory footing in terms of the facts that employment tribunals should consider when deciding whether or not the dismissal is unfair under ordinary principles. So the tribunal will take into account whether or not there's been consultation with the employees, whether or not there's been consultation with a recognised union, whether or not the employer's made an offer to the employees in order to get them to agree for a variation. So typically, a payment or something like that. And what the reason for the change is. So there's scope here, I think, for tribunals to maybe look at the reason for the change where it's not related to a restricted variation. But again, we're going to have to see how that pans out in terms of updated guidance on the current code for dismissal and re-engagement, because that will be reviewed in light of the changes under the Employment Rights Act. So looking out then for the action points in relation to fire and rehire. So points to look out for employers who are seeking to introduce the variation clauses that I've talked about, and look out for how the employers might be proposing to change how pay is structured, where the pay is made up of specific elements, in relation to accommodation or travel, for example, and seeing whether or not that's redefined as an expense or a benefit, because there's a current consultation at the moment which is seeking to redefine the pay elements of it. So it will be important to look out for employers seeking to make those changes that are set out on the slide there. The other point I wanted to make about fire and rehire is that currently it's lawful to dismiss employees by reason of redundancy and replace them with agency workers, because the definition of redundancy only requires an employer to show that its requirements for employees to carry out work of a particular kind have either ceased or diminished. So it would be automatically unfair, on the next slide please, it would be automatically unfair to dismiss an employee if the principal reason is to enable the employer to replace the employee with a person who is not an employee. So this is clearly aimed at what happened at P&O, where they dismissed employees and re-employed agency workers. Now, we think the financial difficulties exception will apply if, in all the circumstances, the employer couldn't have reasonably avoided the need to replace the employee. So like with the restricted variation, a financial difficulties exception will also apply. So having said that arguably an interim relief application would have been better to support this new right, because the employer would have had to have retained the employee or kept paying them. But that provision isn't available. But what we do have instead is changes to the unfair dismissal provision. So these may have a deterrent effect. And so we know that currently employees need to have 2 years continuous service before they have a right not to be unfairly dismissed. And compensation is limited to 52 weeks gross pay, or £118,000 and £223, whichever is the lower. Inevitably, for most workers who I've ever represented in Thompson's, it's a lot lower than £118,000 and £223. So what will happen in January is that an employee who has got 6 months continuous service will have the right to claim that they've been unfairly dismissed. So I know that part of the manifesto was to introduce a day one right, but this was stymied by the House of Lords. So ultimately this led to a deal whereby the government agreed that employees who've got 6 months continuous service will have a right to claim that they've been unfairly dismissed, but the cap on compensation will go. So the new rights will apply to employees who already have 6 months service on the 1st of January 2027, with other employees becoming entitled as they gain 6 months service. It's also important to remember that the 6-month qualifying service doesn't alter the position which currently applies for employees to claim automatic unfair dismissal, such as on trade union grounds or by reasons of pregnancy. They still remain a day one right. It does still only apply to employees. I get asked lots of times about whether or not there's going to be an extension to workers. That isn't part of the Employment Rights Act, although the government has given a commitment to look at employee status. So in terms of further information is available, that's the 2 key points there, but further information is available on our Employment Rights Hub. And I think one of the important things to make clear is that the government does remain committed to implementing the provisions of the Employment Rights Act in accordance with its roadmap, which it set out in July last year and updated slightly in February. And there are a raft of consultations which have been published, and how the government takes that forward in terms of going forward and the rights for workers will depend on how effective the employment rights consultations are, and the responses to the consultations will be in advancing workers' rights. So I just wanted to end there. I think I've gone way over my time. I'm so sorry, but I hope that gives you a
So that
flavour.
was absolutely fantastic. We have gone over time. I won't beat around the bush. So I'm going to let you catch your breath for a minute and just cover off some of the questions that we've had come in that that I can do. So first of all, just to acknowledge, we've had over 130 questions posted. We're not going to be able to get to them all, but I'll try to put some of them to Jo in a minute. All the others, we're going to make sure that we take in-house at the TUC, and we're going to be compiling other resources, some frequently asked questions by reps about how elements of the Employment Rights Act will work in practice. And we'll make sure that they're available to you. We'll make sure they're available on our website. We'll keep you updated. As I said at the beginning of this webinar, now you're in the loop with everything that we're going to be doing for you with regards to this new legislation. So we'll make sure we send you regular updates, access to resources, information about events and other webinars that are coming up about this. But this is a two-way street. We want to hear from you as well. So do send us a message. We'll make sure that the email is posted in the chat and we'll send it out to you. We want to hear about any examples you might have in your workplace where the Employment Rights Act is really going to make a difference to your members and your colleagues. Do let us know. Do let us know if you have any other questions as well, and we'll make sure that all that is included in future resources. We're certainly at the beginning here of a medium to long journey in information about the Employment Rights Act. Right, so we've had quite a lot of questions about Northern Ireland. Things are going to be a bit different in Northern Ireland, and we at the TUC are working with reps in Northern Ireland to make sure that, we're working with unions in Northern Ireland to make sure that reps are kept fully informed about which elements apply to them and which don't. So I'm not going to cover those questions today. I also just want to reference that we've had quite a few questions about changes that were brought in by the Act that happened in mid-February, on the 18th of February. We'll make sure that a link to all of the changes that were made then is included in the follow-up email to this webinar. We'll send that out to you tomorrow. We'll make sure there's a link to the recording and all the resources that we've mentioned. As I said, we've had over 130, I think, questions, and I've noted down some of the more general ones that I think we're going to put to Jo now to see if we can cover those off. So, Jo, first off, is anything in the Employment Rights Act going to be retrospective? Something that might have happened last year or a couple of years ago, or is it only looking forward?
It's only looking forward.
Fantastic, great stuff. And you talked a little bit about employers are going to have to be making quite a lot of changes here. I mean, one of the obvious ones that springs to mind is about the amendment of policies that they might already have. Are you aware of any things that might be coming in to train employers on this? How are they finding out about this, about their new responsibilities and the new practices that they may need to do?
Well, there's quite a lot on the internet that you can look and see what employers are being advised about, and that's some of the things that I've picked up about, particularly in relation to fire and rehire, about how employers are preparing for those provisions to come into effect. So good employers are already being trained on it. They're getting advice from their own solicitors about what they need to do and how to get their house in order in advance. But there'll be, many small employers who are not prepared. I'm thinking of, care homes, hairdressers, that kind of thing, where employers just won't be on top of it. And I mentioned about the Fair Work Agency. Well, that's not going to come in until the 7th of April, so it'll be after some of these provisions become law. Particularly, one of the concerns is about SSP and about making sure that workers don't lose out on their right to that.
Thanks, Jo. Okay, about some of the more specific things that are changing in April. Can you say something about how the 2 years to 6 months unfair dismissal rules, how those changes might interplay with fixed term contracts? Is there going to be anything to consider here?
Yeah, I mean, one of the things is with fixed term contracts is they're going to be able, fixed term contracts that are 6 months, and obviously they're going to be able to claim unfair dismissal. So there might be some tactics about not renewing fixed term contracts, and maybe reviewing them so that they become shorter, so that they are 3 months rather than 6 months. And that might, be the case with probationary periods as well, so that employers, where it was a 6-month probationary period, might start looking to reduce that to 3 months, so that they can try and bypass the 6-month qualifying period to claim unfair dismissal.
Yeah, thanks, Jo. And that's obviously a tactic that employers might start doing for this particular change. All the things that you've mentioned about the changes coming in April, what are other potential employer tactics that you perhaps envisage that they might start trying?
But aside from the ones that I've already mentioned,
someone mentioned specifically in one of the questions about perhaps we've done the perhaps maybe the whistleblowing or the non-disclosure agreements.
So whether or not they strong arm people into signing confidentiality clauses now, well, effectively, those provisions are already effective, and I think it's going to be difficult for employers to sort of avoid, if they dismiss somebody for blowing the whistle on sexual harassment, to try and argue an interim relief application doesn't have reasonable prospects. Because usually those types of cases, it's pretty stark. In some cases, the sexual harassment might be, will obviously be disputed, but in some cases the employer will dispute that that's happened. And so that might undermine an application for interim relief, for example.
Thanks, Jo. So you mentioned near the beginning of the presentation a bit about sweetheart deals when it comes to recognition. Can you talk a little bit more about those and what might protection from those look like?
Right, so what that means is when those provisions come into force, so again, that's not retrospective. So, there is a famous case, I think, which involved journalists, where there was another sweetheart deal with a non-independent union. It only had one member, but because that union the employer chose to recognise them, that completely undermined the NUJ's ability to get recognition there. So that kind of tactic shouldn't happen in the future if there is a non-independent staff association, for example, that is in place and the employer chooses to recognise that won't prevent the union from making an application if they meet the criteria of 10% of the workforce in the bargaining unit being a member of the union.
That's great, Jo. It does, yes, thank you. So we've talked about recognition. Is there any changes to derecognition processes?
Not that I'm aware of, but that's something I might just double check.
For sure. I thought it was quite an interesting question, which is sort of something that we can both look at and report back. So we've had quite a few questions about the practicalities of implementing this, and you've given us lots of good advice already about things to look out for, maybe things that reps can be checking ahead of the change, and of course afterwards. But we know that when reps are going about their day-to-day duties and work in the workplace, that employers don't always make it easy for them. Is there anything in place around intimidation of reps by the employer when they're implementing elements of the Employment Rights Act?
Well, I think there's the current provision under Section 146 of a right not to be subject to a detriment if it's going to deter, prevent an individual from carrying out their trade union activities, then that provision is already in place. So I think if reps are feeling as though they're put to a disadvantage as a consequence of that, disadvantage is broadly defined. So if an individual is put to a disadvantage in the same way it's defined in discrimination, then I think reps could probably rely on those provisions to say that they are being put at a disadvantage. So rather than saying they're intimidated, they can say that they're feeling as though they're being put to a disadvantage as a consequence of, maybe speaking to their members, telling them what their rights are under the Employment Rights Act. Because there is no law against that, but the law would be putting reps to a disadvantage.
That's a great suggestion. Thank you for that one. You talked a little bit about harassment and third-party harassment in particular, and a few audience members, well, I think there's lots of them watching who work in education, have suggested that could this help them in schools when they might be getting harassment from children? Is it intended to apply to them?
Well, I think it is. Let me just be clear, though, about this. So the way that the law is currently, so as of today, is that employers are under an obligation to take preventative measures to prevent sexual harassment in the workplace by workers and by third parties. So I think that covers pupils and parents for those who are in a school. So but the only thing is that currently there is no right for an individual to bring a legal claim in the employment tribunal that they have been subject to harassment by a third party. The provisions that will come into force in October are those provisions which will extend the right not to be subject to harassment by a third party. And that provision won't just be limited to sexual harassment. So I think that's the subject of a future TUC event.
Absolutely. And watch this space, everyone in the audience. These are definitely issues we will come back to, but I thought it was a really sort of interesting question and something that maybe we hadn't looked at before. Okay, here's another one that's maybe a bit more specific. You talked about restricted variations with regard to consultation. Can you give us some examples of what they might be? The question is specifically asked, can a reduction in sick pay, for example, be one?
Yeah, well, it's funny because I have talked about this with colleagues and we think it could be, because it's pay. And I don't think it's caught by the the current consultation. That's looking more at expanding pay into expenses and benefits in kind. So I think it would be caught by sick pay. So if the employer is looking to reduce sick pay, then I think that would amount to a restrictive variation.
Are there any others that you've maybe discussed with colleagues that you think may, not just related to pay, that may become a restrictive variation? All right, I'm not going to put you on the spot. I'm really sorry.
It's
The
sick pay's at the forefront of my mind because, of course, that change is coming in very soon and it affects so many people.
Yeah, absolutely. This isn't an exam. So we talked about a bit about the 0 hours contracts, and well, with regard to not just 0 hours contracts, but that's the example the questioner used. Will these changes be automatic, or is it going to be a process of negotiation with employees and unions in the workplace, with anything really? But that was just the example they talked about.
Yeah, well, I suppose the most obvious example is in relation to sick pay, because that's the only change that's affecting pay. And sick pay is payable to employed earners. And so we can get into all kinds of difficulties. So that might be an issue which comes up, which says that you're not an employed earner. And it's not appropriate or probably beneficial for me to go through that, because I'd have to look through the individual circumstances in order to be able to answer the specific question. But yes, that might be an area where the employer challenges an individual's entitlement because they say that they're not an employed earner, which is defined as somebody who pays Class 1 national insurance contributions, for example.
Thanks, Jo. I think we're going to just try with 2 more questions, and then we've got a question for the audience. So does the uplift in an award apply to failure to consult on 2P?
So it's a failure. So it's in relation to dismiss and re-engage, and a failure to consult under dismissal and re-engagement. So there's a good question that, because I haven't really thought about it.
Again, I don't want to put you on the spot.
Yeah,
but
I'll have to just double
to
check
come back.
that.
We'll come back to that one. And something I think that would interest all members of the audience. I suspect I know what the answer is going to be. Is there any suggestion of changes to facility time?
Yes, there are. So they look like they're going to, because currently there isn't anything about, they're currently in the ACAS guidance, I think, aren't they, rather than the code. And so, yes, those will come. I'm not quite sure when they're coming in now. I think they're in October. So let me just double check.
So yeah, everyone in the audience, we will come back to this later in the year. But I just thought it was a really good question to put to Jo now, I think, because it's going to affect all of you.
Yeah. So I mean, I know lots of unions have got facility agreements with the employer, but I think they will be put on a statutory basis, and they look like, from memory now, looking to come in about October. So again, future TUC session.
Absolutely. Sorry if I've put you on the spot with a couple of those, Jo, but I thought it was really important to raise a couple so that we know these are things that we're going to be discussing. Right, in a minute, I'm going to ask Jo to wrap up with some final points for you to take forward in your workplace. But what we're going to do first is we're going to put a little poll up on the screen, which is asking you to think of one thing you're going to do in your workplace to prepare for the Employment Rights Act. Now, you can type as much as you like. It's not going to show up on the screen because there's so many of you here, but we'll leave that up for a little bit. While I just remind you again that we'll send out the recording and all the resources that we've talked about today to you tomorrow. And also, we're going to be doing so much more throughout this year on the Employment Rights Act. Do stay in touch with us. We'd like to hear about your experiences in the workplace as well. You can email us, or you can reply to one of our marketing emails as well. That the message still gets to us. And any questions we've not answered now, we're going to make sure we take all of that information in-house so that we can provide answers to them as part of our resources. So we'll leave the poll up for a minute. I don't think it's sort of blocking anything. And Jo, I'm going to ask you for your top 3 tips for reps to take back into the workplace to prepare for these changes coming in April.
Well, it will obviously depend on the individual workplaces because, judging by the different questions that have been asked, people will have different priorities. But I think probably the things that immediately spring to mind are that, if you've got 10% of your workers are in the bargaining unit, then apply for recognition and don't worry about any sweetheart unions in the workplace. Check your sick pay policies and make sure that they are meeting the statutory minimum provisions, and remind employers that, if there are redundancies or if there are proposals for fire and rehire, there will be significant financial consequences if they fail to consult with the union where the union is recognised.
They're great, 3 fantastic tips for our audience to take away with them today. So that all remains now for me to say, Jo, you've been absolutely sensational. Thank you for everything today. It has been brilliant. Thank you also to Kate Dearden, Minister for Employment Rights. She's had to leave, and to Paul Nowak, TUC General Secretary, who started us off 90 minutes ago on this webinar with a great introduction and a great welcome. But also importantly, thank you to everyone in the audience. You've been really amazing today. We have learned so much from you, as well as we hope the other way around. We really, really appreciate hearing what's going on in workplaces and getting your feedback. So thank you so much. And we absolutely hope we'll see you again soon for more information on the Employment Rights Act. So have a great rest of the day, everyone, and see you soon. Bye-bye for now.